Good afternoon, everyone. I hope you are all well wherever you're joining us from today. I'm Jennifer Bannon. I'm the Senior Legal Writer for Practical Guidance Competition at LexisNexis. And thank you for joining today's webinar on the ACCC's proposed merger reforms, big tech and recent trends. And I hope you'll find our session informative and thought-provoking, and that you'll leave with some great insights and more confidence in your own take on this important debate. So I welcome all of you, my colleagues and legal practitioners and competition law enthusiasts from all over Australia. We've had over 100 registrations to join today's webinar, from in-house counsel to private practice lawyers and knowledge managers, as well as commercial executives and economists and regulators. So it's clearly gained the interest and attention of many. And I'd like to start today's meeting with an acknowledgement of country. And I'm based in the suburb of Drummoyne in Sydney's inner west, and the Wongal people are the traditional owners of the land I'm on today, and I pay my respects to our elders past and present. Before we dive into our discussion, a quick run through of the rules of our meeting. This meeting is being recorded for anyone unable to attend or who may need to leave early. And the recording will be emailed to you in the coming days as a podcast, so you can return to listen at any point. Bandwidth permitting, please turn your video on whenever you're presenting or talking, but otherwise please turn your cameras off and put yourself on mute. I think it automatically has you on mute and cameras off. Please use the Q&A function for any questions, and we've reserved some time at the end of the session for you to ask some questions of our panelists, so please do make use of that opportunity. So moving now to introductions, I'm delighted to introduce two of my former colleagues from my days at Allens, Jacqueline Downs and Robert Walker, both of whom are very experienced in competition law, particularly mergers. So Jackie specialises in ACCC merger clearances and authorisations, as well as competition and consumer law investigations and enforcement. And she has extensive experience in dealing with the ACCC and other regulators around the world to resolve competition and consumer law issues. And she's advised across a wide range of industries, including media and technology and health and infrastructure. And Jackie is also the chair of the Competition and Consumer Law Committee of the Law Council of Australia, which is, of course, where ACCC Chair Rod Sims kicked off this debate on the 27th of August. And Rob is also a competition and consumer law expert, and he specialises in ACCC merger clearances, investigations and litigation, and ACCC market studies, inquiries and compliance. And he has experience across a wide range of industries as well, including financial services and payments, technology, telecommunications, healthcare, energy and mining and retail, and he practiced for many years in London and Brussels. So I'm sure Rob will be able to share some of his insights from that global perspective. So it's great to have both Jackie and Rob here, and I know that Jackie, for example, worked on the first ACCC, the first authorisation considered by the ACCC, for example, and Rob worked on TPG Vodafone. So with those introductions done, let's dive into this interesting topic, and I'll hand over now to Jackie and Rob.
Thanks very much, Jen, and pleasure to be here, everybody. We're really going to cover two main topics today to reflect the title of the session. The first one is we're just going to take you through some of the key trends in big tech. That certainly touches on mergers, but there are a lot of other issues going on in in big tech at the moment that we thought are very highly topical and are to some extent influencing the ACCC's decisions in other areas. So we'll take you through that, and then we'll take you through the ACCC's merger reform proposal and take some questions at the end. But I'll hand over first to Rob to talk about some of the trends in big tech. Thanks, Rob.
Brilliant. Thanks, Jackie, and thank you very much for the introduction, Jen. What I want to talk about first are some trends in merger reviews, because I think, as Jackie said, that will set up some of the discussion for the ACCC's proposals in the latter half. So if we could just go to the next slide, please. And one more. So what my intention is here is to try and distill what a number of these merger reviews are about. I think it's fair to say, 5 or so years ago, the competition community queried whether or not our current laws or our economic frameworks for thinking about competition in these types of markets were fit for purpose. And there was quite a bit of a debate as to whether or not there needed to be an actual change in the way that we approach competition law. From my perspective, when you look at these mergers, a lot of the theories and the economic thinking behind them actually is drawing on traditional frameworks. The difference is not so much the approach, but rather applying those frameworks to the way that these businesses work. And in particular, when you're looking at issues around access to data and control of data and what that means for entrenchment of market power. As Jen alluded to, I'll be drawing a bit on what's going on overseas here, in part because a lot of these deals are being thought about in many jurisdictions, and there are other jurisdictions where we have a bit more information around what the actual theory of harm, as we call it in competition speak, is. So let me try and distill what can sometimes look like a complex area from the outside. The story starts, at least in Australia, with the Google Fitbit deal. And so this is Google's acquisition of the wearable device manufacturer Fitbit. This deal was cleared by Brussels, subject to certain commitments, but has not been cleared in Australia or in the US, and is still open to investigation in those jurisdictions. The key competition issue, when you look at what the authorities are saying, it is really about access to data and control of that data. And in particular, are concerned that the aggregation of the data coming from the Fitbit devices would be used to entrench Google's position in digital advertising. Other theories which also have this data lens is, well, will there be some sort of vertical foreclosure as a result of this deal? In particular, Google not allowing developers of competing health care devices or healthcare tech to access Fitbit data, or on the other hand, discriminating against manufacturers when they're trying, manufacturers of wearable devices in terms of their interoperability with Google Android operating systems. Now, the European Commission was satisfied that commitments to address those types of conduct would be enough for it to clear the deal. A similar undertaking was offered by the parties or by Google in Australia, but that ultimately wasn't accepted by the ACCC. The next sort of big ticket deal is the Facebook Giphy deal, and this one was actually a merger where Facebook announced its acquisition of Giphy, which is a library of GIFs, as well as it has an adjacent, albeit small, digital advertising business. And when that deal was announced, it was effectively called in by the UK CMA and by the ACCC in Australia. Now, we know that the ACCC is investigating the deal, has been reported in the press, but don't have an articulation yet of what the actual concerns are or the theory of harm is. We have seen, though, the CMA in London last month provisionally oppose the deal. And they did so on the following grounds. One was a concern that there would be a loss of potential competition between Facebook and Giphy. And you hear a lot about this theory of potential competition in digital market mergers. It's the concern that these two, the two merger parties could become competitors or closer competitors in the future, and therefore by merging, you're removing that potential competition, which ultimately lessens competition on the overall market. And the concern here, as articulated by the CMA, is that Giphy, albeit smaller in the digital advertising space, does have a different digital advertising offering. Using GIFs to advertise in a digital manner is different to the traditional banner form that you see on sites like Facebook. And even if Giphy was not going to be as big as Facebook, it provided a constraint in terms of its innovation and a different offering. So bringing the two companies together would result in what we'd call effectively a traditional horizontal effects concern. There was also a concern around a potential for vertical foreclosure. And here it was a concern that rival social media companies either wouldn't be able, or social media platforms would not be able to access, or that the Giphy's GIFs would be designed to only be, or to be more favorably used on the Facebook platform. And so as a result of that, this was a means by which competition would be lessened in the digital, in the social media platform market. If we move to the next slide, a couple of other mergers that, and one which is still being considered, again by acquisition by Facebook of Customer. So Customer is a customer relationship management software, and it allows companies in particular to engage with customers using a multiple mediums. So using email, using Messenger, using SMS. It's currently under review here, but also in London and in Brussels, as well as in the US. Again, we don't have a clear sense of the ACCC's view on the merger yet, but the European Commission a couple of weeks ago have initiated a second phase review. So we have a sense of what they're thinking about the deal. And one of the concerns is about, again, a vertical foreclosure concern, that as a result of the deal, Facebook could prevent rival CRM providers from accessing Facebook Messenger services, which is a very important way of communicating with customers. And also a similar theory that we've seen in Google Fitbit around potentially could Facebook access a whole set of data as a result of the deal, and particularly the interactions between businesses and their customers via the customer platform, which could then be used to benefit their own digital advertising or display advertising business. So again, taking data from the target to potentially entrench a position in a different market. And a final one is the Salesforce Slack deal, which again is a combination involving a CRM system, but this time with a collaboration platform for use by businesses. The ACCC there focused on vertical foreclosure issues, but ultimately decided that the parties wouldn't have the ability or incentive to either favor one platform, for example, by restricting other CRM providers from being interoperable with Slack, or vice versa with the with the Salesforce platform. For me, the key takeaways from all of these mergers is it's really important to get a handle on data and how the data is relevant to the merger, and in particular, not just the data in terms of the market that the target is active in, but how data generated by the target could be used by the acquirer in other markets, and what does that mean for competition. It's also very important, as you've seen here, a lot of the theories are coming out around concepts of around vertical foreclosure type theories to really unpack the abilities and the incentives of the merger parties to engage in that type of conduct. And then finally, to keep an eye on potential competition issues and potentially coming up against a horizontal issue, which you might not think about immediately because ostensibly the two players are doing different things. Okay, so that's a bit of a rundown of where we are on big tech mergers. I'm going to turn now, if we move to the next slide, to consumer law enforcement. So the ACCC, actually among its international peer regulators, is very effective at using both its competition powers and its consumer law powers in order to achieve its enforcement aims. And it might be strange for Australians to think that there could be a different model because we're so used to the ACCC doing that. But in other jurisdictions, the consumer protection arm of the authorities, either they may not be integrated with the competition authority or just not quite as prevalent. We've seen action again, we've seen a number of actions against digital platform players, particularly in terms of representations made around how the players are using or are collating data and then using it. I won't go through the facts of all of the cases that are on screen, but we do, in particular, the ACCC has taken actions against a couple of cases against Google, one in relation to disclosures around geographic or location tracking on the Android system, and the other around the combination of data from Google's services, from its search platform, from YouTube, etc., with its ad tech business, which was previously known as DoubleClick. For me, a takeout from this, particularly for those who might be in-house or with corporates, is the importance of applying a consumer law lens to privacy disclosures. And what we're seeing here, particularly in that second Google case, is it's not necessarily enough to rely on privacy rules and meeting prescriptive requirements. It's important to step back and think, is the way that data is being collected and used being disclosed to customers clearly, and is that being appropriately updated as those changes are made? It's a bit of an art to draft a comprehensive but also readable and digestible privacy policy, but certainly the ACCC is taking actions in this regard from a general misleading deceptive conduct perspective. Separately and more on a reform agenda, we saw the ACCC as part of the digital platforms inquiry really advocate for a strengthening of the unfair contract terms regime, and we've seen Treasury recently issued a draft bill, an explanatory memorandum for comment on what that regime, on a reformed regime. Many of you probably are very much across this, but a couple of comments, because really these reforms are quite significant if they are to be passed in their current form. One is one aspect of the reforms is they will expand, that they will capture a broader range of contracts, because there has been an expansion of the concept of a small business. So that's just a plain practical matter that more contracts will be caught. Probably more importantly, are two aspects. One is the introduction of pecuniary penalties for the inclusion and reliance on unfair contract terms. And these are following the same penalty or the maximum penalty regime as under the ACL, for the other ACL provisions. Any penalty regime obviously increases compliance risk or regulatory risk for companies, but in particular the way this penalty regime works is it's per contravention. And contravention can mean entering into the contract but relying on the term. And also, if you have multiple standard form contracts, which most companies do, it can multiply across different contracts. So you can get maximum penalties here of very significant magnitudes. The other key aspect of to call out is the introduction of a rebuttable presumption, which, and I'm paraphrasing here, but basically would work such that if a term has been found to be unfair, so a substantially similar term in terms of its effect has been found to be unfair, in relation to contracts entered into by the relying party, or where that term has been found unfair in the same industry, then there is a rebuttal presumption that any further terms entered into by the same party or by parties in the same industry that have substantially the same effect would also be unfair. It's fair to say that our concern with that type of rebuttable presumption is it really does cut across a lot of the heart of the unfair contract terms regime and the way the court has approached the assessment as to whether or not a term is unfair to date. In particular, the concept of the notion of whether a term is unfair is a fact-based assessment depending on the circumstances, depending on the entire contract and the commercial situation. So to apply particularly a rebuttable presumption that a term found to be unfair in one contract would therefore be unfair in other contracts across the same industry strikes us as not being consistent with the way the unfair contract terms regime has been applied to date. And finally, the ACCC has advocated for a general prohibition on unfair trading practices. Again, this came out of digital platform inquiry. We haven't heard too much about this to date, so we're only seeing the exact shape, but our understanding is that it is still sort of on the ACCC's agenda. Okay, Jackie, can I turn over to you?
Thanks, Rob. So before we get into the merger reforms, just continuing looking at big tech, we thought we would just, I suppose, do a bit of a recap and an update on the ACCC's inquiries into big tech. As you know, they have been ramping up their expertise in digital markets over the last sort of four or 5 years now, and spent significant resources in investigating different aspects of big tech. And perhaps if we could move to the next slide, please. I won't go through all the different ones in detail. I'll touch on a few of the decisions, but I think it is again instructive because I think it is definitely part of what is informing the ACCC's approach in a number of areas. And these days, big tech extends beyond what we traditionally regard as big tech in the sense of maybe Google and Facebook. And you can see that in some of the cases Rob just took you through. I actually acted for Salesforce on the Slack acquisition, and probably they are not regarded as big tech in the sense of the Google and Facebook, but perhaps medium tech, if you like. But the ACCC was similarly very concerned about the same sorts of issues that have been coming out in the merger reviews and coming out of there, which, as Rob said, is access to data and creation of large databases. It is interoperability of technology, so ensuring that if you have an important piece of technology that is potentially made available to your competitors in related competing fields. It's about self-preferencing, which is where a large technology platform will perhaps give its own businesses better terms and conditions and a leg up, if you like, in competing for work than its competitors who need to access its platform. And it's about bundling, which is where you have more than one business supplying those businesses supplying your services to businesses and consumers in a bundle. And lastly, the killer acquisition, looking at those smaller acquisitions over the years that have enabled the technology platforms to increase their market power and increase their influence in all of these areas. So this really all kicked off, you'll recall, sort of back in 2017 when the ACCC started its very first inquiry into digital platforms, and that was groundbreaking, world groundbreaking at the time. It was really the first of any regulator around the world to conduct such a large-scale investigation into the market power of search engines and social media platforms. And effectively, that inquiry kicked off a number of follow-up inquiries, but the main findings from that inquiry was that Google and Facebook have substantial market power in search and social respectively, that this enables them to accumulate consumer data to a large scale, which further entrenches that market power, and that they have an incentive to misuse that market power in online advertising markets and in relation to news media businesses. And that final report was delivered, as you can see on your screen, in 2019. And then they commenced consulting over a news media bargaining code, which was one of the recommendations of the report, that there be a code to address the imbalance of bargaining power between the platforms and the media businesses in Australia. And that bargaining code was eventually finalised last year, and since that time there have been a number of media organisations who have come to some agreement. The code isn't actually in force. The code is in force, but there's no designated platforms. But it seems to have had the desired effect anyway, that because the platforms want to avoid being designated, there have been a number of agreements reached, and the ACCC has authorised some smaller parties to collectively bargain, and some of those negotiations are still ongoing, but it appears to have certainly had the desired intention from the ACCC's part and the government's part. Some of the other recommendations coming out of that, first was that the ACCC itself created digital units, and that unit has been very active in investigations, some enforcement actions as we've seen, and also in further inquiries. And so we had the next inquiry was in relation to private messaging services. And then the second inquiry was in relation to app stores, and so that was delivered last year. And if we could go to the next slide. So the ACCC decided in the most recent report in relation to supply of app services that Google and Apple both had market power in relation to app stores, and that the terms of access to app marketplaces for app developers, that there was unequal bargaining power there. It also looked at the effectiveness of self-regulation and determined that further work is needed in that area as well, and again expressed concerns with self-preferencing and the use of data. And a number of recommendations were made in relation to those app stores that the ACCC made, including, for example, a very topical issue because there's been some overseas legislation and court cases as well, including that in the app stores the apps be allowed to direct their customers to other payment platforms. So one of the issues is that Apple and Google require use of their own payment platform in their app stores. And recently you may have read that there was a semi-win by Epic Games in the US, where the court found that that the app stores should allow at least a link within the app platform to other payment systems. So this is another area of that bundling and tying that the ACCC and other regulators are concerned about. And the other inquiry that has recently been finalised, it hasn't yet been released, is the ad tech services inquiry. And this, I think the final report was released to the government the end of last month, and we're waiting for the government to release that final report. But that final report certainly looked at the impact of Google in the ad tech supply chain, again looking at implementing some rules to manage conflicts of interest, self-preferencing, allow users of ad tech services to better assess the price and quality of those services, and boost data portability and interoperability. So in general terms, you'll see that there are, as I said, a number of themes coming out of these inquiries around the sorts of activity and behaviour that the ACCC believes and other regulators around the world have a concern in relation to big tech. And that has led to some calls for separate regulation of big tech and some concerns that traditional competition law might not be sufficient or might be too slow and too cumbersome and too piecemeal to address all of these different issues, and has led to some calls for ex-ante regulation, which Rob is going to take you through briefly now before we get on to merger reform. Thanks, Rob.
Thanks, Jackie. If we can move to the next slide, please. So as Jackie said, a number of jurisdictions, there's legislation and regulation being debated that we'd refer to as ex-ante regulation. So basically setting up upfront behaviours and conduct that those who are subject to this regulation should not behave in, or that they're required or obligations on their part in terms of what they're proactively required to do. And as Jackie said, it's coming from a sentiment that whilst we might have the tools under competition law to address some of the questions in these markets, there's a concern that it moves too slowly because the investigations take a long time, and then there could be court processes, etc. So the approach here is akin to, I suppose, what we see in other industries, for example, the telco industry, where there is upfront regulation in terms of what companies can do and cannot do. The precise approach in terms of the regulatory regimes that are being proposed differs a bit between the different jurisdictions. At one end, you have the European Commission, which is working on a Digital Markets Act, which is still under debate, which basically sets out quite a prescriptive list of do's and don'ts for digital gatekeepers. And without going into the entire list, what they're really getting at are things like do not self-preference, but do ensure interoperability with your platform in order to encourage competition. In the UK, we're seeing a slightly different approach where they're consulting on more of a code of conduct that is principle-based, talking about things like the need to act fairly, the need to act transparently, rather than being prescriptive in terms of the actual conduct in question. The ACCC has said that they're watching these developments very closely and will be considering whether it's appropriate to include similar regulation in Australia as part of their fifth market inquiry into as part of the standing inquiries that they have in digital platforms. So it remains to be seen. Definitely one to watch this space, and I think important to for those who are in these markets, just to keep an eye on the extent to which there are divergence of approaches across jurisdictions, because obviously these markets do have an international dynamic, so that will where there are different requirements imposed according to the jurisdiction will obviously make compliance more complicated for the companies who are subject to them. Okay, over to you, Jackie, for the merger reforms.
Thanks, Rob. And if we could just go to slide 11. So as Jen said, the ACCC a couple of weeks ago at the Law Council conference, which I was chairing, we were lucky, if you can call it that he chose the conference to announce these merger reforms. But I'm not sure I like using the word reform because I'm not sure anything does need reform. So we'll talk about it as an overhaul of Australian merger clearance process. And he also, further to Rob's discussion just now, announced there that next year he will be consulting on ex-ante digital platform regulation as well. So certainly a lot going on. But this on your screen just really outlines a summary of how Rod Sims expressed the ACCC's concerns in relation to the current merger regime and why he believes that it needs to change. So the first problem Rod has identified is their lack of success in merger cases. And we know the ACCC has lost, I think it's about 7 cases in the last 20 years in court. Of course, the ACCC is significantly more successful than that because there are a number of mergers each year that the ACCC either blocks, only accepts with undertakings, or in fact the merger falls over at an even earlier stage and the parties withdraw because of competition concerns raised. And that's not even to mention the number of mergers that don't even get to the ACCC because there's legal advice provided that they're unlikely to be approved. So the ACCC is a very significant regulator in this regard. It is taken very seriously by global companies and their firms overseas advising them. And so we do think that the ACCC's concerns here are misplaced, and that the small number of cases that have gone to court that the ACCC has lost is not reflective of really a problem with enforcement in this. And those cases are really cases which most practitioners would say were sort of borderline or clearly not an issue. Obviously the ACCC has a different view of that. So that's his first concern. The second concern is he's indicated that he thinks Australia's regime is out of step with the rest of the world, and that most of the rest of the world has a mandatory regime. Certainly it is the case that some jurisdictions have mandatory regimes, but I don't think it's correct to say they all do. Certainly there are a number of jurisdictions that do not, and even in those that do, they are quite different to the proposal the ACCC has put forward. He thirdly indicated that there are concerns in Australia about increasing levels of competition, and that these reforms or these changes are needed to restore effective competition in Australia. He hasn't yet done, or we have not yet seen any real analysis done of mergers that have been cleared in the past to see if there has been a problem, but certainly the ACCC and Rod Sims's view is that a number of the mergers in the past have led to higher prices. There isn't any real evidence for this that I am aware of, but it's certainly a concern that he has expressed. And generally speaking, I think he feels that the process at the moment is skewed towards clearance, and we can certainly see that through the proposals that the ACCC has put forward, they are definitely trying to skew the other way towards not clearing mergers. We might move to the next slide to go through the proposals themselves. So the first point to make is that possibly one of the most significant points is that there's a change from the current voluntary and non-suspensory nature of Australia's merger clearance regime to a formal mandatory and suspensory regime. So at the moment, most of you will be aware, there is actually no obligation to notify the ACCC, and there is no breach of the law in not notifying the ACCC, and that a merger can complete without ACCC approval so long as the ACCC has not obtained an injunction from the federal court. In order to prevent a merger from going ahead or to unwind a merger, the ACCC does actually have to take the merger parties to court, or sometimes the merger parties might need to seek a declaration from the federal court if, for example, they do need a mandatory approval such as FIRB, which is not forthcoming without ACCC approval. But ultimately it is the court, the federal court, that will decide whether or not a merger needs to be blocked. So the proposed reform changes that in making over certain thresholds, and we don't know exactly what those thresholds are yet, making notification mandatory over certain thresholds. And so you will not be able to, without contravention of law, to complete a merger over those thresholds until you've obtained ACCC approval. And the ACCC is also planning to retain its ability to call in mergers below that threshold. So one of the benefits we see to the ACCC of the current regime is that they are actually, they have jurisdiction over all mergers, not just mergers over a certain threshold. And in most mandatory jurisdictions around the world that Rod Sims has referred to, the regulator actually cannot block mergers that fall below those thresholds. So mergers can go through unless they fall above the threshold. Now, what the ACCC is proposing here is the best of both worlds. There will be a mandatory notification above the threshold, but even below the threshold, the ACCC is planning to retain jurisdiction to call in a merger that it has some concerns with, even if it's not a mandatory filing, and to block that merger if it feels that's necessary. So that is probably the first significant change to this process. The second is the legal test. There's been a lot of debate over the test over the years and court cases on this. The law refers to a likely substantial lessening of competition, and the courts have in the main interpreted that to mean a real chance, not more probable than not, it is less than that, but a real chance. Not fanciful, but a real chance. And Rod Sims actually wants to water that down fairly significantly to a possibility that is not remote, which seems to be a pretty low threshold for having a likely negative impact on competition. The second way in which the kind of balance of proof switches a little bit is that at the moment, as we said, the ACCC must go to court effectively and prove that there is a substantial lessening of competition. And what the law does is prevent a merger or prohibit a merger that has a substantial lessening of competition. Whereas the proposal by the ACCC is that it can only approve a merger. It is satisfied that it does not substantial lessening of competition. Now, the nuance is slight, but I think it is an important one, that here the ACCC has to actually be positively satisfied there is no substantial lessening of competition before it can even clear a merger. And you might find there are cases where the ACCC is not satisfied it would lead to a substantial lessening of competition, but is also not satisfied that it will not, and in which case it cannot grant approval. There's a new deeming provision the ACCC has also suggested including, whereby an acquisition will be deemed to substantially lessen competition where it materially increases or materially extends substantial market power. Now, this is said to be necessary because the test of whether something leads to substantial lessening of competition is quite factual and sort of depends on what the future will look like with and without the merger. And in a couple of cases, this has rested on the likelihood of new entry or the likelihood of an alternative buyer. And for example, in the Pacific National case, the court found there was not likely to be a substantial lessening of competition due to Pacific National taking control over a rail terminal because there really wasn't any prospect of new entry anyway. Factually, that is what the court found, that there wasn't a real prospect of new entry either way, so no new entrant who's going to want to use the rail terminal in any event. And the ACCC has a problem with this because it still is of the view that acquiring the terminal would substantially increase the company's market power. And so they want this new deeming provision so the court does not have to look at the exercise of, well, is there likely to be new entry? Is there likely to be exit? It doesn't have to look at the counterfactual so much, but the current state of affairs, does this enhance the market power? And that would be the end of the exercise. And we certainly have a problem with that because we think, if a merger does not substantially lessen competition, it should not be prevented. Going hand in hand with the mandatory filing notification is the review process. So at the moment, as I indicated, parties get an effective complete rehearing before the tribunal, and that can lead to new evidence, new witness statements, expert evidence being called, and witnesses being cross-examined, as occurred in the TPG and Vodafone case, where some 20 odd witnesses were brought before the court. What would happen, what the proposal by the ACCC is that that ability to challenge the decision be limited to the Australian Competition Tribunal. It would be on the merits, but only based on the information before the ACCC. Now, this is similar to what we have in our current formal merger authorisation process, which has only been used a handful of times. Having done one of those authorisations, as Jen said, the first one, I can say it is an extremely onerous process to have to front load all of your possible evidence that you might need in a worst case scenario to put before the ACCC, just so you will have that evidence if you ever need it to go to the tribunal. In that case, we ended up not going to the tribunal, but still a very, very onerous and expensive exercise to put all of the expert and other evidence and information that you could possibly need before the ACCC to preserve that ability to use it before the tribunal. And then there is a prospect only of judicial review before the federal court, and so also really removing the really important role the court plays in cross-examination of witnesses and in assessing witness evidence. And finally, back to digital platforms specifically, there are going to be some specific thresholds and rules applied to digital platform mergers because of the killer acquisition concern the ACCC has, although they haven't released the detail of that yet. So just moving on to the final slide, I've probably covered most of this, these potential implications as I've gone along, but just to sort of summarise before we open up for a few questions if there are any. So firstly, obviously the lower legal test, there's a real potential for over-enforcement here, and it really, in my view, tips the balance in favour of blocking mergers. And it's really a policy decision, and it's a matter for government whether we want to have a system which is skewed in favour of preventing normal economic activity such as mergers, which can be efficiency enhancing and lead to innovation, whether we want to skew that way, or whether there is an overarching concern about competition and concentration that means we should skew in favour of blocking mergers. But I do think there is a real risk of over-enforcement, and it does diverge from overseas regulators. The real possibility that is not remote chance is a lot lower than international substantive tests that we are aware of, which are much more in line with the real chance that is currently applied by the courts. Under the mandatory process, more deals are certainly likely to be caught. It will be much more onerous on both parties, and frankly the ACCC to be reviewing a lot more mergers, many of whom should not be even remotely a problem. And continuing uncertainty for business due to this call-in power, which again, as I said, is contrary to overseas experience. There'll be curtailing of the court's important role, as I indicated, confining it to evidence before confining the tribunal's review to the evidence before the ACCC, and then confining the court to judicial review only. The deeming provision is really out of step with international practice. It introduces a two-tier test, and in our experience, deeming provisions have only been used in nascent competition regimes such as Vietnam, which did have a deeming provision for a little while when it came in, but once the courts and the regulators become more sophisticated in applying a substantial lessening of competition type test, that deeming provision in Vietnam was actually removed. And so we think it really is a backward step to introduce a deeming provision in Australia's sophisticated regime now. And finally, there's the big tech regime. I think this will be caught up in the broader ex-ante regulation as well that they're consulting on next year that Rob went through. Part of a much broader international debate about that, and remains to be seen how much lower than what the ACCC is actually proposing for all mergers, how much lower they can go in relation to the thresholds for big tech. So I think that really concludes our presentation, and happy to open up for any questions for either Rob or myself.
Thanks so much, Jackie and Rob. I'm sure there will be, I certainly encourage people to pop some questions in the Q&A function there. And perhaps while people are thinking of what they might like to ask you, I might just jump in with one. It's really around the ACCC's proposed merger reforms. And I was just wondering about sort of likely next steps. So I know the ACCC has said that, you know, they've kicked off this debate, and Sims said in his speech that the ball's not in the ACCC's court, and that it only makes recommendations, and it's really for Treasury and government to make the decision on whether, you know, merger reform and policies should take place. So I was just wondering if you have any insights into what are the likely next steps and sort of timing around this debate that the ACCC has sort of kick-started.
Thanks, Jan. Look, really good question. And I have to say it's not entirely clear and not entirely, as you said, it's not really up to the ACCC anymore, but it is kind of largely in government hands. I think it's certainly fair to say that the ACCC is going to continue to agitate for this. I know there's a number of speaking engagements Rod Sims has coming up where he's going to continue to push with this, and he has reached out, I think, to a number of sort of representative bodies in Australia, such as the Law Council, of which I'm the chair of the Competition Committee, to have a dialogue. And it is, you know, to be fair to the ACCC, they have very much put it out there as starting a debate and starting a discussion, not kind of like this is it and government, you should just go and implement it. So they, you know, my sense is they are willing to consult, and we are certainly very happy to engage in an evidence-based open debate on some of these issues. Government hasn't really shown a lot of interest, and they just might have a few other things going on at the moment that they need to prioritise. Also, there's an election coming up. So I think my guess, and Rod may even have accepted this, is highly unlikely to see any real movement, I suspect, from the government side of things until after an election. And I think the ACCC knows that, but I think they feel that this is going to be quite a long debate and consultation process, and so they're wanting to kickstart that now. I think one other thing I should say, in case some of the audience thinks, oh, well, what are we worrying about it now for? I think there's two reasons for that. One, I think it is important for business to be engaged in the debate when they have the opportunity, and to be thinking about the implications of some of these reforms and to be talking to, you know, their companies about it. To make sure that business is involved in this discussion. But secondly, I think it's also important to be aware of the context in which Rod Sims is going to be conducting merger reviews over the next 12 months. He's put forward these potential reforms, and I think it could also signal a bit of a hardening of stance by the ACCC on merger reviews more generally, because I think it's I think he won't want to be criticised, if you like, for sort of letting through mergers too easily when he's putting these reforms on the table. So I think there is a broader context to be aware of, you know, at the moment as these reforms are out there being discussed.
No, thanks, Jackie. That's really helpful to understand. And I suppose my next question, I'm hoping someone will come up with one, but I'm happy to ask another one, is sort of around big tech and what Rob was talking about in the early piece of our discussion is, you know, the ACCC is proposing that there should be ex-ante regulation of big tech, and then simultaneously they're saying, you know, big tech needs specific merger laws to deal with acquisitions in that space. You know, and I know that obviously they've got the Digital Platform Services Inquiry and they're going to be consulting on those proposed changes next year. Do you think it's likely that they'll sort of combine both of those thoughts and that they'll consult on changes at the same time? How do you see that working?
Do you want to take this one, Rob? Or?
Sure. My understanding, Jen, is it will be together, and that as part of that fifth inquiry, it will be both the ex-ante but also the merger-specific proposal, which is similar to how it's being done in other jurisdictions. For example, in the UK, that the package that's being consulted on is together. So I think it makes sense intuitively to me that it is combined.
Fantastic. Thank you. So we have had another question. from one of my colleagues actually at LexisNexis. She's the writer for corporations. Do regulators in other jurisdictions have the ability to call in acquisitions in the same way that Sims is proposing?
I'm happy to take this one, Jackie. The most similar to what the chair is proposing is the US. They do have certain thresholds. They're very complicated, so I won't try to summarize them, but they have a residual call-in power as well. And most litigated mergers in the US that go through their litigation process past sort of that initial injunction stage are mergers that have been called in. There are other jurisdictions sort of, but it's not common among mandatory jurisdictions. So for example, European Commission and most of the European member states do not have that call-in power. And that's why we saw in those jurisdictions actually quite a debate around whether their jurisdictional thresholds are sufficient to capture mergers, particularly in the big tech space where the target's revenue is not quite high enough to capture the revenue thresholds that are set there. So it's actually interesting when you look at all those cases that we discussed sort of at the start of this discussion. The ACCC is involved in all of them at the moment under their current regime, because in my view, actually, the Australian regime is very flexible and I think arguably has the broadest jurisdiction at the moment of anyone. The UK has a similar voluntary test, but there are some thresholds in the UK, albeit there's quite an expansive approach to jurisdiction that is taken by the UK authority. So the ACCC is not missing out at the moment. It definitely has a seat on that international table, and actually some of those authorities, for example, the Austrians and the Germans who weren't notified of some of those deals, are actually taking action because of those of not being notified.
Thanks, Rob. We have one last question, which I'm hoping we can answer from the Q&A, and it's around whether there are any proposed timeframes for consideration of merger proposals, which I'm not aware that legislation has been drafted at this stage. Rob and Jackie, do you know if there have been any sort of thoughts on likely timeframes if the ACCC's proposals get traction?
Well, Rod Sims indicated that there would be timeframes. He hasn't indicated with any detail what they would be and how closely the ACCC will have to stick to them. I mean, I have some sympathy with the question because at the moment, certainly in the informal regime, the timeframes are certainly slipping quite a lot. And also there's complete flexibility on the ACCC's part to change those. What concerns me a little is that even under the formal regime we have, the timeframes are set out there, but really, again, they are largely in the ACCC's hands to extend because if parties don't agree to an extension, the merger is automatically deemed, and the ACCC doesn't make a decision in the required time, the merger is deemed to be blocked. So we would definitely want to avoid something like that and have put to the ACCC, I think, some comments have already been put to them quite strongly that, the timeframes would need to be tightened up. But look, they did indicate that under the regime they're proposing, there would be some fairly strict timeframes, but we certainly haven't seen the detail around how it would work.
Well, thanks so much. I know we're getting close to 1 o'clock, so I think we'll wrap it up there. But thank you all for attending today's webinar, and thank you in particular to Jackie and Rob for sharing your time and your expertise. I certainly really enjoyed hearing, Rob, you talk through what's happening in big tech. The ACCC is so active in this space. It's something that affects us all. So, and they're, looking at inquiries and taking cases. So, it was great to hear that. And Jackie, I also enjoyed hearing your take on the proposed reforms, and I particularly liked your very succinct table, which
I'm not sure I can take credit for it, Jen, but
well, the table you spoke to distinctly looked at the current regime and the proposals, because there's a lot of words out there, and it's great to have it sort of distilled so succinctly. So thank you both. And as I mentioned at the beginning of the session, the webinar has been recorded and we'll be emailing you in the coming days with a recorded version of the webinar, so you can come back to it if you need to. And if you'd like to hear more about latest legal developments in competition law, we have a fortnightly roundup that you can subscribe to here at Practical Guidance Competition. So thanks again, everyone, and bye for now.